rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in Vortex Corporation versus Denkowitz et al. Our case number CV12069. Each side is allocated 20 minutes for oral argument. Appellant may reserve a portion of that time, sir, if you wish to choose, or if you choose to do so, for rebuttal. If you want to do that, you need to keep track of your own time at the podium. Using the clock. Now, out of respect for counsel, I would ask those in attendance, if you have cell phones, to make sure they're either off or in vibrate so counsel are not interrupted as they present to the court. We have read the briefs. We've conferenced the case earlier this morning. We encourage you to keep that in mind as you present oral arguments. Our proceedings are being recorded and will be posted actually to YouTube in due course. As you begin your argument, please state your name and the party that you represent. With that, let's hear first from Mr. Royal.
Thank you, Your Honor, and may it please the court and counsel. I represent the appellants Denkowitz and Engelhardt, and my name is Rob Royal with the firm of Tiffany and Bosco. Judges of the panel, the Vortex assets, which consisted of intellectual property used for the water industry, were valued before the dissenter's rights value date in a number of ways. They were valued by the Miller Capital Group, who specializes, among other things, in business valuation, at $15 million. And later on, that same entity valued these assets, the intellectual property and the assets of this company and the company itself, at $20 million. These are factors that the trial court judge did not appear to take into consideration. In addition, management itself, through its private placement memorandum for Vortex Pure Water, also put a value of $2 a share, or about $9.4 million. But I think more importantly, the investors, the savvy investors that went into this deal, decided that these assets were worth them putting up $5 million or thereabouts. And our own business valuation expert, John White, who is certified in business appraisal and well qualified to value businesses, found it the value of this company and assets to be $20 million.
Was that before the transfer to VPW or after?
Absolutely before. His standard of value is clearly set forth in his report, and he was designated and quoted the very statute we're dealing with, so he was assured of conducting the valuation at the right time. Judge at the trial court really did not look at all of these factors. In fact, I think it ignored the value of the Vortex technology and the Vortex assets, and ignored the fact that business people, business persons, business valuators, and savvy investors thought these assets had a lot more value than the $61,000 that were attached by the insider who was the expert for the other side, Mr. Rabin. The value was existing at the time that the valuations were done. It was based upon standard valuation practices that are set forth in Mr. White's report, for example, as well as Miller Capital. Interesting.
Excuse me for interrupting, but let's assume for a moment that we agree with you that there's a lot of good evidence on your side of the valuation issue. Aren't we really looking only to see if there was an abuse of discretion here?
Well, that certainly is debatable.
Or to see if there was clear error under the clearly erroneous standard, perhaps?
Well, we believe the right standard is a de novo review because you're applying a statute, and I seem to read Mr. Morrow's brief as suggesting he could agree in part to that, so I think it is a de novo review.
So this court, do I hear you right, should redo the valuation from the start?
I think there's an opportunity for the court to do that, or maybe you're going to see some suggestions that will send it back to the trial court for, on remand to gather additional evidence that may be needed. But there's certainly enough evidence in the existing record, I believe, including Mr. White's report, and besides the other information presented to the court, to do your own valuation.
Let me ask, you have a couple of times indicated that your view that the trial court didn't take into consideration competing valuations. And I understand that, understand your position. But one way to look at this record is the trial court was given a lot of different valuations, or at least two different valuations, and picked one. What causes you to say that the trial court didn't take into consideration competing valuations?
Well, there just isn't any evidence of what it fully took into account. I think that to ignore the substantial valuations that were done by independent persons, besides our own expert, suggests that the court ignored it. And if this isn't a baseball arbitration, he picked the lower number.
But let me ask you, then you indicated ignored a couple times. What evidence is there that the court ignored these as opposed to picked a different one?
Well, I don't see a sufficient evidence in the ruling by the trial court judge to suggest to undertake this valuation and discard these excellent values that are put upon this business.
Did either side, and I'm not saying that this was required, but it dawns on me to ask, did either side present evidence from which a methodology might have been applied to reach some number between the two rather extremely differing valuations?
Well, I think the answer to that is yes. With respect to John White's report in particular, he used 3 standard valuation methods. One of those was the internal valuation method that included the valuation really done by the management of the existing company at a much lower level. And so the evidence ranges in the $20 million range into the $9 million range based on the $2 per share, even down to the $5 million range, because that's what the investors, who I believe were savvy enough investors, decided that that's what this is worth.
Did your side argue alternatively for some value other than the highest value?
Well, we, of course, argued for the highest value. We also presented to the court these other numbers so the court could pick and choose. And obviously, the court completely ignored any of those other factors in determining what the value, prior to the date was.
And in your argument that this should be a de novo review, I'm thinking about that, and because, as I understand it, you're arguing that because there is a statute involved that purports to, I don't know if it purports to define, but at least places one limit on what fair value is. Mm-hmm. Is that the statute you're talking about that is applicable here and makes this de novo in your view?
Yes, it is. And in fact, I think the pro-finish case, which is kind of the main case out there regarding fair value in Arizona, particularly because it's a dissenter's rights case, also looked at the de novo review because it applied the statute. And that's really, to me, what is at issue here is, the judge not applying the factors and, examining the statute to find out the fair value and just discarding and not concluding that any of those other factors came into play.
What was there anything in the statute that describes fair value? Was there anything there that was disputed? I mean, it sounds like everybody agrees that, well, let me back up. As I recall, the statute requires that the valuation be made right before the event to which the dissenters are dissenting. Mm-hmm. And I gather everybody agrees that's when the valuation was to be made. So what statutory interpretation is involved here?
It's the beginning of that statute under 10-1301. The value of the let me back up. The standard of value to be used is fair value, and the definition of the fair value is under the statute. The value of the shares immediately before the effectuation of the corporate action to which you're referring, mm-hmm. to which the dissenters objects, excluding any appreciation or depreciation unless it's inequitable to exclude that.
Is there any part of that is in dispute here, what the statute that you just read covers?
No, I don't think there's anything that's in dispute on what the statute and the statutory standard. This is an application of that standard, in this particular case. Moving on for a minute, I think I want to spend a little time on the $2 per share issue. We have some case law that assists us in this area. The American ethanol case has been cited, indicated that the price at the time of the event is an excellent and a very good indicator as to the true value. That arguably would be the $2 per share. In addition, the pro-finish case talked about the fact that the sale is the best evidence of the existing value, And so we got some case law support that we can look at to determine whether or not the value is correct. And again, I think it's important that the American Ethanol case also affirmed the standard of let's examine all of the factors here. And even if you do apply, a different standard, which I think you must be considering, you have to look at whether the judge, made error or possibly abused his discretion by not, discussing and counting in some of these factors that I've been mentioning.
Was there are you arguing a failure of the judge to make detailed findings and conclusions that he should have made?
Well, I wish he would have. We all hope that as trial lawyers, and this judge does have a history of, at times, just making a decision and not explaining it, like in the motion to dismiss issue, which led to our motion for reconsideration. That's something I'd like to address. The reason I want to address that is, practically speaking, we all knew going into this litigation, and as the litigation went on, that the proposed Vortex operating structure, which we call the VIP agreement on our side, dated in May of 2006, does have an indication that despite the fact that it's been signed by everybody, it's a proposed structure, and the other side's position, long known and still is, that hey, this wasn't an agreement. So as a result, we brought in claims, including promissory estoppel, that would allow us to, have the fallback position that if it wasn't an agreement, we'd have other remedies, including partnership. And Judge underneath looked at the complaint, despite the fact that we allege an agreement, that this was a business of co-owners that were sharing profits. We set out the profits, the shareholder ownership, and we also set out where some of those profits were coming from, which was the Vortex entity, and the reason and rationale for creating the agreement, which is solid, that the judge ignored this partnership idea, which of course is the fallback. If you don't have a corporation or an LLC, you got an association of persons in business together, and you've got the classic definition and statutory definition of a partnership. In fact, our statute under 29-1012A says that even if they didn't intend to be partners, the law will recognize your de facto partnership when the structure is set up.
And so your argument here, as I understand it, is that on the face of the what I think your side calls the VIP agreement, on the face of it, it expressed an intention or desire or purpose to form an LLC.
It did.
Your argument is that while that apparently was not accomplished, nonetheless they formed a partnership, and the statute helps there because it says they don't even have to intend it.
That's exactly correct. And so that that is the fallback position, which allows us to say, okay, then they had a partnership. And of course, it's disputed whether any of the partnership or the agreement went into place or not, but it was executed, and there's evidence as to why we did it and that it was believed to be. And in fact, there's great reliance in this case by Mr. Engelhard, who wouldn't even sign his employment agreement until he was assured that the VIP agreement or this partnership arrangement, which changed the distribution and their, solidified their interest in the company and stock, went into place. And then we cited cases that, demonstrate that a partnership can exist and use a corporation as a vehicle for administering, and it's a good mechanism for a partnership to have a corporation to administer to the business of the company.
Now, would you remind me quickly what the LLC, or if not partnership, was intended to do separate from the Vortex Corporation?
Yeah, the problem arose when Mr. Dankowitz, who is one of the inventors, realized that the inventions that he was creating were not done for the benefit of the company he was an owner of. That would be Vortex, or he planned to be an owner of under his agreement. In fact, it was set up that the ownership of the patented technology would be with another company called RCT. So he said, time out, that's not right. So he went back to his partners and said, look, if we're going to be working in this company, we need to have an agreement where our inventions are going to pay off for us. And so they said, okay, then we need to restructure this entity and this arrangement, which is what they did.
But they never restructured Vortex.
They never did restructure Vortex. It had to stay in place. The Dankowitz and Engelhard were still employees of Vortex under the employment agreements. Now, some of the terms of their employment agreement did change with that later agreement because that allowed them to, be sure to get their stock rather than be conditioned on anything.
I gather the judge ruled as a matter of law, or at least on motion, on your partnership argument. But then the enforceability, and I'm using that word sort of generally and maybe not precisely, but the enforceability of the VIP agreement went to the jury, and they said no. Doesn't that sort of moot out or defeat your argument?
It does not at all, because the jury did find in favor of us for promissory estoppel. And if we would have had the ability to take to the jury the partnership argument, we could stand up and tell the jury, and this is where the real prejudice and harm to me comes in, that, ladies and gentlemen of the jury, if you don't believe this was an agreement executed by the parties, then you may find, as the judge has instructed you, that it was a partnership, because it was a more than two people going into business as co-owners, as demonstrated by the agreement, that at least the terms that are set forth in writing, and they're going to share their profits. And here's where the profits are going to come from.
I'm sorry but I've forgotten if the promissory estoppel verdict form was the one that found in favor but awarded zero damages.
We got a little bit of money, about $6,500 out of that.
No, but the one I'm thinking of was a different one.
Yes, it was. I think that's on the other side, in which I think that was a tortious interference and $0 were awarded.
I believe it is.
All right. I'd like to reserve the rest of my time for rebuttal at this point.
Very well. Thank you, Counsel.
Thank you very much.
Mr. Morrill.
Thank you, Your Honors. Rick Morrill on behalf of the Applees, the Vortex Corporation, Ted Lamb and his spouse, Cody Ramsey and his spouse. I want to pick up somewhat from where the court started with some of their questions. First, the standard of review here with respect to the fair value hearing is not de novo. Pro-finish is the source for this information. The standard of review is simply, is there substantial evidence to support what the trial court did here with respect to the fair value determination?
What about, I think Pro-Finish said, did it not, that this was a mixed question of law and fact, and therefore we'll review it de novo.
Well, with respect to some aspects of what they were looking at, but when it came to actually determining the fair value, they said this is an abuse of discretion, essentially, with respect to that particular part of the case. And I don't think anything having to do with the statute is at issue here. What it's at issue is which of the expert witnesses did the trial court believe. And the trial court here made express findings of fact and conclusions of law with respect to his ruling with respect to the value determination. And unless those findings are clearly erroneous, those should be upheld. Plus, all the evidence and conclusions, reasonable conclusions, are to be viewed in the light most favorable to supporting the trial court's decision. Let me also address the first statement Mr. Royal made. He claims that what Miller Capital did and what the people who put together Zuvo, the Delaware LLC, did was value the intellectual property of Vortex. Well, that's not what it did at all. The evidence was abundantly clear, and to the extent you have a transcript of what went on at the fair value hearing, the testimony was those valuations from Miller Capital were based upon projections of what sales might take place if a product could actually be developed that could be made at commercial scale, which it still had not been made at commercial scale, had no sales force. If, in fact, you have a huge influx of capital and these sales actually happen as specified in the projections, then this is what the corporation could be worth. Those were certainly never intended to be, and no one ever thought they were, expressions of fair market value at a particular point in time. These were simply projections based on a lot of assumptions that might or might not ever take place. With respect to the $2 per share issue, you can search the record thoroughly, and you will not ever find that Mr. Denkowitz or Mr. Engelhardt argued to the trial court during the fair value hearing that the $2 per unit price was something they were entitled to. It is simply not there. They never argued that. They never even suggested that. Their figure was $20 million, and as I've described in the briefs, the way Mr. White did it, If you start with the projections, every kind of approach you take is going to come back to $20 million because that's where you started, with those projections, as if those were actually going to take place.
So you quarreled with his assumptions?
I do. With Mr. White's assumptions, absolutely, and his entire approach to how he valued the company, and I'll address that in a second. But with respect to this $2 a share issue, Profinish and American Ethanol do say that under the circumstances of those cases, what was paid for the stock is the best evidence of the value of the stock. But those were third-party, arm's-length transactions. For example, in Profinish, the court makes the point that this was a all-cash deal to Profinish from the purchaser with no risk to the shareholders in the old corporation. It was simply a sale of the assets. And so, of course, the best measure of value is what a third-party arm's-length transaction would give you as the value for the stock in an entity. American Ethanol is exactly the same kind of case. It is a situation where there was a public market for this stock at $3 a share. And the court said, of course that's the right value, because that's what people were willing to pay for it in the open market in an arm's-length third-party kind of situation. No one here ever testified or thought or believed that the transfer of the assets from Vortex Corporation to Zuvo was an arm's-length third-party, all-cash kind of deal with no risk to the shareholders in Vortex, because it was simply a Hail Mary. Let's see if we can't resurrect this thing. Maybe we can make something of it. But none of that ever happened. The court certainly had the opportunity to review Mr. Rabin's qualifications. He's a 30-year investment banker. He makes his living by being able to properly evaluate what a corporation is worth. He's not a professional witness. He's not a professional appraiser. But his job day in and day out is to make certain determinations as to what is something worth to an investor. In his professional career, he has provided fairness opinions. Fairness opinions come up when an outside entity wants to buy all the stock or assets of an existing corporation. The board of directors is under an obligation to determine whether that offer is fair to the shareholders. Mr. Rabin has prepared fairness opinions for corporations. Mr. Rabin has been on the board of directors of corporations that had to evaluate offers and fairness opinions. He's advised boards of directors with respect to fairness opinions, and he's been an investor. He is eminently qualified to make a determination as to what a corporation is worth. To the extent that he had some relationship with D2M, a company that had a relationship with Vortex, the trial court was fully aware of that. It was not hidden. It was out front, and everybody knew it. So the trial court, in his discretion, had to choose between two extremes. And he picked the extreme that I think he thought was the appropriate circumstance given the situation. You got to remember what Mr. Rabin was valuing. He was looking at Vortex Corporation on the day before it was going to sell its assets to Zuvo. It had $100,000 cash. It had $4 million of secured debt. The debt was secured by the intellectual property of Vortex Corporation. The bank was ready to call the loan. There were no employees. There was no product that could be made at commercial scale. There was no sales force. There was no marketing infrastructure. There was essentially some intellectual property, some of the patents of which were about to expire. And given the circumstances with the bank, no one is going to invest in that entity. Given those circumstances, Mr. Rabin said, I need to evaluate this entity as it exists today because that's what the statute requires. And when I look at it, there is nothing here of much value without a huge influx of capital, without bringing on a bunch of employees. I'm going to try to look at it as if I was starting this company back up again. What do I think it might be worth? And that's where he came to the $62,000 conclusion based on a current value of projected potential revenues for this entity. Mr. White's opinion was flawed. Before I go into that in much detail, let's look at what we were talking about here. Appellants now say before this tribunal, all we wanted was our 3% in Vortex. Well, that wasn't what they wanted. At trial, as reflected in the pleadings, they were demanding either 3% or maybe 6% or as much as 15% of Vortex Corporation. They wanted it in cash, and they wanted it based on the Miller valuations. Even though the appellants had made no capital investment in Vortex, they never made a loan to Vortex, and even though they received generous salaries for more than 2 years, they wanted an additional payout that no other shareholder was in a position to get. They wanted to be treated as a special class of shareholder. That class was one that took no risk, made no direct investment, but got to cash out early based on projections of what might someday be created. And that's simply not how things work.
Is there anything in the record, by the way, as to why the jury awarded 3% instead of 6% for the 2 years' work?
No, Your Honor. There's nothing. Now, in doing the valuation calculation, Mr. White used the Miller reports, which, as I've already indicated, everyone agreed were based on sales projections that might never happen and that needed significant capital influxes. Mr. White also treated Vortex, an Arizona corporation that still exists, as if it was the same as Zuvo, a Delaware LLC that no longer exists, as if they were the same entity, even though he acknowledged that they were two separate entities. And instead of valuing Vortex as a standalone entity as required, he attributed significant value to Vortex as if it was Zuvo. And then he valued Zuvo on nothing more than the projections. He did not even value Zuvo on what actually had been raised from the investors. Only $5 million in change was raised. He valued the corporation as if it had raised $10 million. So already there was a major problem with the valuation.
Mr. Morrill, I think I understand what you're arguing regarding arguable flaws in Mr. White's assumptions. But I hear the other side, I think, arguing that Vortex must have been worth a lot more than the 61 or 2,000, or else these investors wouldn't have put in a whole ton of money into the new corporation.
I understand that. And the investors in the new company were all friends and family of Ted Lamb and Ted Lamb himself. And it was an attempt to get them out of the $4 million loan from Comerica. It was an attempt to save the Vortex intellectual property to the extent it had some value. And it was an attempt to try to resurrect the company. So people were willing to step up with Ted and try to make something happen. But that doesn't mean the corporation was worth $20 million.
I think I hear you saying, but not in these words, that what I just said doesn't have much significance because it's not an arm's length transaction.
Correct.
Is
And
that-
the record
is
was
that
quite
kind of what you're saying?
And the record was quite clear that's exactly what this was.
Yeah. Okay.
Now, if Vortex and Zuvo are really just the same entity, one would have to seriously question as to whether anything even happened here that would have allowed Mr. Denkowitz and Mr. Engelhardt to have dissenters' rights. Because if it's simply the same entity, maybe they don't have any rights with respect to as a dissenter.
I'm still a few sentences behind you in my thoughts.
Please, Your Honor.
Are you arguing that Mr. White didn't follow the statute that requires the valuation to be before the transfer of the Vortex assets?
I am, Your Honor. He did not.
Could I ask you a question about Mrs., and I hope I pronounced this correctly, Mrs. Denkowitz?
Absolutely.
Why is she in this lawsuit?
Well, initially, she was named in the lawsuit as a defendant. At the time, she did not move to have her position dismissed under Rule 12b, as she could have, which then waived the argument. She then actively sued my clients in a counterclaim.
It would have waived an argument of lack of minimum contacts, that sort of lack of personal jurisdiction. It would have waived that.
Yes.
But it wouldn't have waived an argument that, hey, you have no substantive claim against me.
Well, until she then counterclaimed against my clients.
That does seem significant, but why do you think so?
She's then subjected herself to the jurisdiction of the Yavapai County Superior Court by actively taking a role in the case.
Well, true, but I'm thinking she's already waived that actually in the same document called an answer or a minute answer, where she didn't assert lack of personal jurisdiction.
I think more importantly, Your Honor.
But it doesn't, the counterclaim is what I'm getting at, is the counterclaim wouldn't waive her potential 12B6 motion saying, you haven't alleged that I did anything to be on the hook here.
I understand what you're saying, Your Honor, but more significantly, I think this issue is moot. Both Ray and Caroline Denkowitz filed for bankruptcy in Rhode Island. Our judgment against them has been discharged in its entirety. So even though she may have had a judgment against her at one point in time, that judgment against her no longer exists.
I tend to think this might be something we should be advised about.
Yeah, well, there was a bunch of
one side or the other. Or
there were a
both?
bunch of pleadings that came out with respect to the bankruptcy. You guys may not have seen them. This lingered for about a year because of the bankruptcy in Rhode Island, and the court declined to move forward with the appeal until that was resolved.
Well, and the briefs address that issue, though, so if
They
a
do.
supplemental filing's in order to resolve it, I'd encourage you to
I
think
don't
hard
disagree
about
with you on that, Your Honor.
I would ask you, if you would, to address, we talked about a little bit with Appellant's counsel, the 12B6 motion. And,
Certainly, Your Honor.
The partnership issue?
Yes.
Yes. Those counts of the complaint where the court dismissed them in part allowed the appellants to argue to the jury that Exhibit 17 was a contract. It allowed them to argue to the jury that there was a promissory estoppel. They argued that because of Exhibit 17, my clients had fiduciary duties to the appellants. The jury decided it was not a contract. There was no fiduciary duty. Why they decided there was promissory estoppel is subject to a lot of speculation. The amount was such that it didn't make much sense for us to fight about it. The reality is, though, Your Honor, and the record is once again very clear on this, after Exhibit 17 was executed, Mr. Denkowitz said, that's not going to work. We have to do something different. And almost a year later, he proposed a different proposed restructuring. So I think that's what the jury decided, that there was no contract, because Mr. Denkowitz himself, after this document was executed, says, no, hold on, we have to do something different. We can't do this because the corporation would have to change from an S to a C, and it can't own a wholly owned subsidiary as an LLC. And so, essentially, from a factual point of view, there was no agreement, whether it was for a partnership or anything else. I think Judge Jones said it best, that he was unaware of any case law or statute that would indicate that a partnership is, in fact, a default or fallback position when the specific intention of the parties was to do something other than create a partnership. It was clear that they were trying to create an LLC or something else, which Mr. Denkowitz then said, no, we're not going to do it that way. We're going to do something else. To then leap to say that now this somehow forms a partnership doesn't make any sense. They were not prejudiced by the fact that the judge granted that motion, because they got to argue it three different ways as to why Exhibit 17 granted them relief.
So do I hear you correctly that in defending the court's grant of that portion of the 12B6 motion, that the reason why that was not error is what then happened at trial in sort of analogous settings?
I would not say that exactly, Your Honor.
I want to make sure I understand what.
I think the trial court made the correct decision, because Subpart B of the statute on the formation of the corporation says if the parties have or intend to do something different than a partnership, then the partnership statutes don't apply. And so it was clear that they were putting together something other than a partnership. Under those circumstances, there is no partnership by default. But in addition,
I was going to say, help me.
even if you determine that the trial judge should have let that go to the jury, I think it's harmless error because they got to argue 3 different ways as to how they were entitled to relief as a result of Exhibit 17, the proposed restructuring. To let them have a 4th theory, I just don't see how, particularly when the jury decided there wasn't even a contract, and Mr. Denkowitz himself said, we weren't going to do it that way, we're going to do something else, how that would have created any rights to anybody with respect to that Exhibit 17.
And that includes, though, the promissory estoppel jury verdict?
Well, they got relief on that, but on what basis, none of us really know. But that's what the jury decided. The jury decided 4 issues in their favor and 9 in ours of the 13 different causes of action and theories that went to the jury. In conclusion, Your Honor, we think that the trial judge here, all their arguments here are with respect to things that were clearly within the discretion of the trial court. The trial court made its decisions. There were expressed findings of fact and conclusions with respect to the fair value determination. The fair value determination was clearly supported by the evidence. The judge had to decide who was more credible. He made that decision. It shouldn't be second-guessed here. That's the job of the trial court. He has the opportunity to view the witnesses and judge their credibility. And I thank you very much for your questions. It was really helpful to know what you were thinking about with respect to these issues. Thank you very much.
Thank you, Counsel. Mr. Roy, rebuttal.
With respect to the motion to dismiss, what happened at trial and whether there's relief is irrelevant. What you got to look at is the well-pled facts of the complaint taken as true. And so when Judge Jones says that I don't see any indicia in this complaint that there was allegations of partnership, that is, in our view, a mistake. And we have cited to those well-pled facts in our complaint to help, guide the court. Next, clearly Pro-Finish did discuss mixed questions of fact and law with regard, to this valuation issue and applying the statute. And from the briefs and the arguments I've heard today, I really do conclude that it is a mixed question of fact and law at this point, and that the Pro-Finish, a dissenter's rights case, is very important in applying the correct standard of review. Vortex Pure Water, or Zuvo, was a shell. It had absolutely nothing. It had, no business, no product, and it ended up having assets that were transferred in exchange for value from Vortex. It had different ownership. It had different management. And, it became a different entity as a result of the valuable IP technology that was transferred in exchange for value to Zuvo. Mr. White did projection on income, which is the standard and most useful way to value businesses, as he said in his report. And, while that does include income projections, it includes historical figures as well. It includes a study of the national economy and the specific industry with respect to the water that then existed, which at that time the evidence clearly shows a burgeoning industry. He also used valuations of the internal guideline method, which is, as I said earlier, looking at what management valued this at, and then he also used a comparison or market approach. So he used standard approaches here and weighted them as he deemed appropriate. Next, I wanted to speak a little bit about, taking a look at all these factors. Both sides rely upon Highfield's, a case, that stands for the proposition of looking at all factors. And the point that I want to close on is this. When you look at that quote, it's actually in their brief. I kind of wish I would have done it now, but in the Highfield case, they talked about let's look at all factors, and they list some examples. And specifically, they say, let's take a look at the asset value. That is a factor that should be determined. And when you're valuing a company, how do you not look at the assets? I don't get it. You shouldn't be limited to a financial statement that shows $61,000 and ignore the very product of the company that you're valuing. And with this de novo review that I think is appropriate, I'd urge the court then, to reconsider this. That's all I have, unless you have some more questions. Thank you all
Counsel.
very much.
Thank you. We appreciate your argument today, counsel. We appreciate your briefs as well. We will take the matter under advisement. We'll issue a ruling in due course. We will also take a short recess while we set up for our next oral argument. Counsel, we will remain on the bench while we do that. Please take all the time that you need, and then we'll start when you're ready. So thank you all.